Good afternoon. You are listening to the NPZ Law Blog. My name is Michael Nachman. I'm a law clerk here at NPZ Law Group. And this afternoon, we're going to be discussing the H-1B season and how it is almost upon us. The question that we're going to be asking is your Human Resources Department ready? Under the 2019 published final rule by the United States Department of Homeland Security, an electronic H-1B registration process has been implemented, which requires a $10 registration fee for the cases that will have to be filed by April 1st, 2022, which is the cap season deadline. One of the main goals under this regulation is to conduct the H-1B lottery before accepting petitions so that the prospective H-1B employers know in advance if the case will be selected in the lottery before submitting a full and complete H-1B filing to USCIS. We have a couple questions and answers below that are adapted from information that's available about the H-1B program and has been modified to provide prospective H-1B employers and H-1B employees with guidance about how to prepare for the registration process for the upcoming 2022 H-1B non-immigrant visa cap season. Our first question, what is H-1B cap registration? H-1B cap registration is a USCIS electronic registration process for prospective petitioners seeking to file H-1B cap subject petitions. Second question is who is covered by the electronic H-1B registration rule? The registration is only for prospective cap subject petitions, not for cap-exempt employees such as universities or qualified research institutions, nor employees who have already counted against the cap. Our third question, when will the H-1B non-immigrant visa registration period begin? The process is rolled out as follows. 1. The initial registration period starts at least 30 days in advance in the beginning of March. 2. Initial registration period begins at least 14 days before the first day of petition filing, April 1st, and it will last at least 14 calendar days. 3. If selected, a prospective H-1B employer has at least 90 days to file H-1B petition, and USCIS may reopen registration at any time without notice being required. Our fourth question, what is the government's filing fee to register? There is a $10 non-refundable registration fee for each beneficiary. Our fifth question, what information will be required by prospective H-1B employers and prospective H-1B employees to register for the electronic registration program? The following information will be required as part of the electronic registration program. Your full name, date of birth, country of birth, citizenship, passport number, gender, an employee attestation that there is a bona fide temporary job offer for which the prospective H-1B employer intends to file an H-1B petition. Our next question, how many registrations can be submitted by a prospective H-1B employer for a prospective H-1B employee? The answer, an employee can submit one electronic registration for each prospective employee. Any prospective H-1B employer must submit a separate registration for each prospective H-1B employee that seeks to register. No duplicates are permitted. However, it is important to note that multiple employers can submit one H-1B electronic registration on behalf of the same prospective H-1B employee. The next question, what happens if a duplicate electronic registration is submitted for any prospective H-1B employee? The answer, if an H-1B employer submits a duplicate or multiple H-1B electronic registrations for the same prospective employee, all registrations for the prospective H-1B employee will be rejected. However, a prospective H-1B may have multiple prospective H-1B employers submitting electronic registration forms on their behalf. Will a prospective H-1B employer be required to provide information about the offered position in the initial H-1B electronic filing? Information about the position to be offered to the prospective H-1B non-immigrant will not be required to be initially submitted, but it is important to assess the requirements for the position and the qualifications of the employee to ensure that a prospective non-frivolous H-1B petition will be filed. Is the employer required to establish eligibility for H-1B status when submitting the registration? No. If the petition is selected in the H-1B visa lottery, then the prospective H-1B employer will be required to provide information about the employee organization, and the specialty occupation position being offered to the prospective H-1B non-immigrant employee. Is a labor condition application required to be filed with the Department of Labor before the H-1B electronic registration can be filed? No. But the labor condition application preparation will certainly be advisable to do ahead of time, including determining the prevailing wage, posting, and filing with the Department of Labor before the electronic H-1B registration occurs to ensure that prospective H-1B employer organizations have a certified LCA if selected, and submission of the application can occur within a short time of the resulting H-1B electronic lottery results. The next question, does the prospective H-1B non-immigrant professional and specialty occupation employer get a receipt upon completion of the electronic registration process? Yes, a confirmation number will be assigned by the USCIS, which will be a different number from the USCIS receipt number. How will the electronic H-1B lottery be conducted? USCIS first conducts the lottery for the first 65,000 members and includes all registrations. USCIS then conducts a secondary lottery for the 20,000 numbers reserved for U.S. advanced degree holder registrations. This process change was designed to increase the chances of prospective H-1B employees with a master's or higher degree from a U.S. institution of higher education to an estimated 16%, or roughly 5,340 workers. What does the prospective H-1B non-immigrant visa employer do once they receive the information that a prospective H-1B non-immigrant has been chosen in the lottery and been allotted an H-1B visa number? The next step after the lottery has been conducted is for the prospective H-1B employer to prepare and file the H-1B petition with USCIS. The prospective H-1B employers will be given 90 days to file petitions for selected employees. Because of the low barrier to entry by paying a nominal fee of $10, which measures has USCIS put in place to deter frivolous applications? USCIS confirmed that it intends to monitor the electronic registration system for prospective H-1B employers who submit a large number of H-1B registrations and then later file only a few selected petitions at a significantly lower rate. May an attorney submit an electronic H-1B registration for a prospective H-1B employer and prospective H-1B employee? Yes, an attorney will be able to file electronic H-1B registrations for their clients using the Form G-28 Notice of Appearance as an attorney. How are the electronic registration fees supposed to be paid? Answer: payment for electronic H-1B registrations must be received on the government website at www.pay.gov via ACH or credit card. The government will not accept cashier's checks or money orders. Cash, certified bank checks, and/or money orders are prohibited. The next question pertains to the benefits of working with prospective H-1B non-immigrants to prepare documents and the LCA before a potential notification that a prospective H-1B employee was selected in the electronic registration lottery system. According to USCIS guidance, H-1B petitions chosen in the electronic registration process, submitted at the beginning of the 90-day period, will be adjudicated first. OPT cap-gap planning is required to minimize interruptions in work authorization before October 1st. Careful contingency planning for cap-gap cases is necessary as new electronic registration applications will not result in cap-gap benefits unless they are selected. Prospective H-1B employees must carefully review all cases thoroughly to ensure that cap-gap cases are timely filed if chosen in the electronic registration process. Our next question: are there any other strategic considerations that prospective H-1B employers need to consider for the upcoming cap season? Prospective H-1B employers may want to consider advancing the recruiting timeline by at least 3 months to identify prospective H-1B employees who will need H-1B cap sponsorship by late November or early December. For more information about the H-1B professional and specialty occupation work visa, please feel free to contact us at 201-670-0006 at extension 107. For more information about the H-1B process, please feel free to visit our website at www.visaserve.com. Our client relations manager can be emailed directly at info@visaserve.com. Our immigration and nationality lawyers and attorneys would be pleased to help you with your employment-based, family-based, and individual immigration matters. Thank you for tuning in to the NPZ Immigration Law Blog podcast, and we look forward to helping you with your immigration needs. Thanks for listening.